Hello, everybody. Hello, Nana Laura. Hello, Manny. Hello, Michelle Moreland, honey. Hello, C-Rex. Hello, Wire Mother. Hello, Mortimer Duke. I got some Ricky for you tonight. It's near the end, though. Hello, Donald Westerdale. Hello, Linda Applegate, honey. Oh, you get a big yawn from Ava. Big yawns. Big yawns from our pretty little girl. You want that? You want one of those? Can you get that? Well, that was quick. I didn't even get to click on the next person. No. She didn't hesitate. She got that one out right away. Let's see if I get the rings at the top, if she'll grab a ring. Oh. I guess so. That was 3. Hi, Billy. Yeah. K-Rise T. K-Rise T. K-Rise T. Oh, Christ. Mad Gabs. I'm on your time now. My mom was Meemaw. Meemaw. That's what she chose. Hello, Charlie. I know exactly who you are. Hello, Buzzy Pug. What? Having her get her own treats out? She likes it. She seems to really enjoy that part. Hello, Spider-Man. Thank you. I love the cut. I love the cut so much that I got this exact shirt in like 8 patterns. It fits so nice. It's so flowy, and I'm in love with this keyhole on the neckline, and they're all open shoulder. This is my favorite style of shirt. So, short sleeves, flowy, lightweight, and in so many pretty colors. Thank you so much. I needed new shirts. If you hadn't noticed, my selection of shirts has been dwindling. Yeah. Just kind of rotating through, like, 5 or 6 of them. Yeah. Billy, your tail is going to be a problem, and I can just tell. I know this. Yeah, Billy's going to be fun tonight, I can tell. Oh, Mortimer Duke's doing a Hot Pocket commercial. Well, it's a good thing I'm not here to please anybody. Other than myself, I'll do what I like. That's the side you get to see. I get the cute side. So, the thumbnail guy, he's like 3 cases in, but we get to see royalty tonight. He and Earl actually have the same gray, but in different patterns. I loved Earl so much, just like my shirt. I loved Earl so much, I had to get another one in a different pattern. I love my tuxedo kitty. Even though he is like the biggest butthead. He is. Hi. Hi. I'll give you a licky treat when I start the cases. I'll start the cases. Get that tail back where I can see it.
Morning. Sir, what is your name, please?
Cameron Shako.
Okay, thank you, Mr. Shako. We are on the record in case 252654FD. Sir, you're zooming in with us from the Leelanau County Jail this morning for purposes of a probation violation arraignment. Also zooming with us is Mr. Jarboe. He is a defense attorney provided to us through the Indigent Defense Council, and he's here to assist you with the arraignment process. I'd like to open a private breakout room. It's a place where you would be able to speak with Mr. Jarboe about the alleged probation violation as well as the recommendations from the probation department and your right to contest the charge at a hearing.
Okay,
Let me open a breakout room. Are you comfortable going in a breakout room?
I am.
Okay, and I'll speak with you when you come back. All right, welcome back, gentlemen. We're on the record again in case 252654FD. Mr. Jarboe, did you have an opportunity to speak with Mr. Shako about these allegations?
I did, and thank you for that opportunity. We did review the alleged probation violation claim that he failed to obtain a CAM device. And he's aware of what that allegation is. He's aware of what's contained on the recommendation section of the probation violation report from Leelanau County. He would enter a plea of not guilty and ask that the matter be set for hearing before the judge. He is going to be asking the court to again authorize assigned counsel. If that happens, we would like the file to note that Mr. Burdett had previously been appointed to represent him on the underlying matter. And then once that's completed, we'd be happy to discuss bond.
Okay, thank you for that. Let's see. Let me make a note on here. Okay, Mr. Shako, I do have to put you under oath and ask you some questions. If you would please raise your right hand. Do you swear or affirm that the information you're about to give me is the truth to the best of your knowledge?
I do, Your Honor.
Okay, thank you, sir. You may put your hand down. What is a good mailing address for the court to utilize for you?
Traverse City, Michigan, 49685.
Do you have a telephone number you readily utilize?
I do.
Do you ever use email?
Yes, I do. It's at hotmail.com. It's just at hotmail.com.
And what are your living arrangements? Do you have a mortgage? Do you pay rent? Do you live with others?
We pay rent. Me, my significant other, and my child, and our other 3 children pay rent. I have 4 children, ranging from 16 to 3.
And what's the amount of rent that you pay each week or each month?
Right now, my significant other and her mother is helping pay the rent, but that's around 1,800 a month.
What's your legal marital status?
Single.
Do you have employment at this time?
I do side jobs. I do have employment. My employer, who owns Treaty Fish Company, was one of the victims stabbed at the Walmart incident. Her lung was punctured. So work has been on pause, on standby, but I do have work. I am still employed by them. They're just in recovery.
Okay. So do you have any source of income or support that you receive on a regular basis?
Yes, my significant other and her family have just assisted with helping me take care of my 118 for my old device, and they are assisting with helping me pay for my new device.
Is anyone familiar with this Walmart incident that his employer apparently got poked with? Wow, that's crazy. Oh my gosh, Tiny Kitten and Billy, like a thumb apart from each other. This is scary. Hello, Patrick B. I can't wave at you right now, but hello, buddy. We're doing a kitty show.
So that I do not miss any PBTs, that which I have not missed at all yet, nor have I blown up.
Okay, so but you don't have any kind of pay of any sort that comes in on a regular basis for you?
Yeah, because of my work being on pause, the only other income I have right now until I find another job is per capita, but that goes to my child support.
Okay. Let's see. Do you own any real estate or vehicles?
I do not.
Do you have any money in a checking account, a savings account, any cash on hand or digital currency in your name?
I have $5 in my name in my account. That's about it for right now.
Okay, thank you for that. I am going to appoint an attorney to you. He or she will be reaching out in the next week or so. I do have a request on here for Attorney Burdette, since he's familiar with working with you. And we'll have the probation department schedule this for a hearing. And Mr. Jarboe, what would you like to offer regarding bond?
Well, this seems a little unusual, this probation violation matter. The allegation is that he failed to obtain a CAM device, but in reading the other information, it indicates that this really was a financial issue. It indicates that the probationer explained to the probation officer that at the time he didn't have the funds for the CAM device, that he was still making payments on his original testing unit. He tells me, and I don't see any indication in the paperwork that's contrary to this, that he has not blown hot while he's been on probation, that he's remaining sober, um, including testing as recent as yesterday morning, which was negative, and on the 10th, 2 days ago, which was negative. He's explained to me, and he's quite nervous about what's going on today because he was told that he had to turn himself into the jail, which he did do on instructions yesterday morning. So he's been sitting now at over 24 hours. Um, his significant family and others have now raised the funds to pay the back money due for his PBT and also the money for his CAM device. He's had no other pending violations, which would cause him to stay in jail. It's interesting that the recommendations are to assess the 365 days in jail, but also to continue probation, which is inconsistent with each other since these are 1-year offenses. He would like the opportunity to be released today on a PR bond. He will continue to do his testing. You can see him nodding his head yes and no. I've told him that he needs to let me speak before he addresses the court, but he's nervous about what's going on.
He's been nodding like a goofball this whole time.
He's told me that he's involved in counseling, he's involved in AA meetings, he's doing everything that it would seem to me that we as a court would want this gentleman to do. The probation officer elected to move ahead with the violation, an alleged violation. I think it's appropriate now that counsel's been appointed to have the matter scheduled for a hearing. Let him, the court to consider a PR bond with conditions that he continue to test as required, that he contact his probation agent to make sure that he's testing the way the agent wants him to test, whatever that may be, and that he's not in jail in a debtor's prison at this point because he didn't have the money to pay for these machines.
Michelle Moreland, did you write a new song just for us? I love it. I love it.
Which I've always found to be somewhat problematic for our courts to order people to do things that they have to pay for that they don't have the money to pay because they're indigent. But regardless of that, so that would be our thought: is the court consider a PR bond, set the matter for a hearing, let Mr. Burdett or whoever is assigned the case assist him. But again, there are no positive tests. He's not drinking, according to what he tells me. Thank you.
Thank you, Mr. Jarboe. And just to give a little bit of info on this, it looks like having community corrections review the case, perhaps the probation department is feeling that maybe Mr. Shako is not a good candidate for probation, but by having probation continued, having the jail sentence and referring it to community corrections, it would put him under that umbrella. So there'd be perhaps some financial assistance related to that. As far as no positive PBTs, I just see a lot of some misses and depleted battery and failing to fulfill other obligations related to probation. And I think that's the crux of this whole thing. So with that being said, I am going to remand Mr. Shako until this hearing, and Mr. Burdett will be able to help him navigate his way through the violation hearing.
This was
All
all
right. With
financial.
that being said, we are all set, and I'll get a copy of this sent over to you, Mr. Shako.
Well,
All right, we have the Antrim jail. With Mr. Schreiber, And when he comes in here, he should be able to hear me at this point. I did see him on Tuesday for a related matter. It would be case 26-5103 FY. Bond was set at a 10%. And he said he was going to obtain counsel, which to my knowledge has not occurred yet. And with the probable cause conference coming up so quickly, perhaps that can be revisited.
And when is that scheduled, Your Honor?
We've got February 18th for the PCC, and the prelim is the 25th.
Is that on the 5103 file, the original one?
That is correct.
Okay. And the date of the preliminary exam was again, please?
The 25th, Wednesday, the 25th.
Okay, very good.
Good morning, Mr. Schreiber. Can you hear me?
Yes, good morning.
Good morning. So this is case 26-5107 FY. You're zooming in with us this morning for arraignment on a new charge. We also have Defense Attorney Jarbeau zooming with us. He is with us through the Indigent Defense Council, and he's here to assist you with the arraignment process. I'd like to open a private breakout room for him to be able to speak with you about the allegations in this new complaint, the nature of the offense, the maximum possible penalty, and have you come back after you've spoken with him. Are you comfortable with that?
Yes.
Okay. Here's an invitation to join the breakout room.
Okay.
I'll see you in a minute. Mr. Jarbeau, did you get a copy of the praxis? Oop. Welcome back, gentlemen. We're on.
You know this isn't Wisconsin court because that oop would have been an ope if it was.
On the record again in case 26-5107 FY. Mr. Jarbeau, were you able to have a conversation with Mr. Schreiber about this case?
Yes, to a degree. We did review the allegations, the facts, and the charge in this new file. I did explain to him what the charge was and the maximum penalty in Michigan. He understands those, and he's waiving the need to have those read into the record. And he's asking that the court enter a plea of not guilty. As far as an attorney, on this one and also on the original charge of which he was arraigned on Tuesday, at this stage, it still appears that he wishes the opportunity to get his own lawyer. So I did kind of make sure he understood that he has court on the first file next week, and he'll have court dates on this file coming up too. And but that's his desire.
Thank you for that, Mr. Jarbeau. All right, very good. And let's see here. We have a mailing address of P.O. Box 44. Yes, sir.
I would just wonder, we can adjourn this now. I think we're well aware of what's going on here. I'm Ryan Schreiber, King David, the Lion of Judah. I like to wrap this up. I'll be leaving the country soon.
Okay.
I have a lot of important things to do.
Oh, okay. Well, we will provide you your ticket.
This is really a waste of my time.
All right, I can appreciate that. So I'll just tell you that you do have the right to remain silent. Anything you say orally or in writing may be used against you. You have the right to a trial. You have the right to the assistance of an attorney and to have that attorney present for all questioning and any subsequent court proceedings. If you find that you can't afford an attorney, the court may appoint one to you at partial public expense. You also have the right to a preliminary examination, and we're going to schedule that for February 25th at 11 a.m. and we'll schedule a probable cause conference for February 18th at 8 a.m. And that, except for setting bond, which I'll set at, let's see, we're going to do a $5,000 10% bond. we'd ask that you follow all terms and conditions of any open court case within the state of Michigan, that you not display any threatening, intimidating, harassing, or violent behavior toward anyone.
Don't leave the country until the case is concluded.
And
Ma'am,
that
I'm sorry, ma'am, but, are you still, are you still proceeding with this? I think we're well aware of this. I'm gonna be leaving the country. We need to wrap this up and adjourn this, and get this on the way, get the ball rolling here.
I'm on that same page with you, and to that end, I'm going to send a copy of this over to you, and just reiterate, please don't display any violent, threatening, or intimidating behavior, no weapons of any kind, and I'll get a copy to you. Thank you for meeting with us.
Thank you. All right, now we go finish lunch.
They're at the booth titled Nisqually Third Room. Your name?
My name,
Yes.
Kellen Crocker,
Thank you.
both with a K.
Both with a K. There we go. Thank you. That was helpful.
Your Honor, Mr. Crocker was in a single cell. I would need a breakout room in order to meet with him.
Okay. We can set you up. So, Mr. Crocker, you're gonna be prompted to enter a breakout room with Attorney Dutch there, who's an attorney, and she'll talk to you before the arraignment today.
Okay.
Okay.
Thank you.
Thank you. All right, and let's see, back to you. Let's see, at Nisqually Third Room, I believe that was Miss Dutch. Are you ready to proceed?
I am, Your Honor. I spoke with Mr. Crocker. We are here for arraignment under 2026149 DUI. We will waive further arraignment, stipulate to probable cause for purposes of today's hearing, enter a plea of not guilty, request a court-appointed attorney. Mr. Crocker does receive public assistance.
All right, thank you. All right, Mr. Crocker, to that charge of driving under the influence, the court will enter a plea of not guilty and appoint public defense to represent you, so you'll have assigned counsel moving forward on this case. Next, I'm going to turn it over to the attorneys to make recommendations on release conditions while the case is pending. And I'm going to start with the prosecutor, Attorney Pinkston. Go ahead.
So this is a DUI that came in a couple of days ago. Yesterday was a refusal, court found PC. This is a DUI collision where the PBT was 0.4. The BACs ranged from 0.35 up to 0.387. So significantly high BACs. As I stated before, it was a collision. I believe.
How do you function at that level? Like, I wouldn't even be able to walk to my car, much less have the capacity to start it and drive anywhere.
Leave at the Capitol Mall area. Surprisingly, there are no, I believe, no DUIs in his history. He does have criminal history, but not it's not DUI related. So we do have concerns about the facts of the case. So I don't have an objection to a PR release today, but in exchange for that, I would be asking him to be placed on pretrial services monitoring with a 24/7 alcohol monitoring device, like a SCRAM bracelet. I would ask that he be ordered to report to pretrial services by end of day tomorrow. I don't yet know their schedule, but I'm hoping they're open on Fridays. Outside of that, in order to abstain from any drugs or alcohol, no bars or taverns, do not drive without license or insurance, no law violations, no refusals of a breath test if once requested from law enforcement, and appear at all court hearings.
All right, thank you. So
Thank you.
just so I understand, I'm gonna get one of those electronic devices.
Well, the judge hasn't ruled yet. That's just what the prosecutor's recommending.
Okay,
Yep.
sorry, this is my first time.
Sure.
All right.
And
Okay, go ahead.
I did let Mr. Crocker know in lieu of bail, as a less restrictive alternative and a more appropriate condition, that the court may require 24/7 monitoring, and given the BAC level, that may be appropriate. But this is a first DUI. There are no similar priors. And it looks like the last conviction was about 7 years ago. So Mr. Crocker has been maintaining law-abiding behavior at this point. So given that he would not have the ability to post even nominal bail, I think the recommendation is probably appropriate.
All right, thank you. Thank you both. So, Mr. Crocker, you will be released today on your own recognizance, meaning no need to post a bond or anything like that. Conditions of your release are as follows: to not commit a criminal law offense. The court is, I'll cut to the chase. I am going to order that scram device. I'll talk about that in a minute. In addition to that,
like, goes in your car and you blow in it, or?
Well, that's not what the scram device is, but I'm also going to require that. And so that's an ignition interlock device. That's going to be a court order. And that is something that you'll need to either have installed in your car, or if you're not driving, there's a declaration you can submit that you're not going to be driving while the case is pending. But
even with a scram and an ignition interlock, I still can't believe that they're giving him a PR bond. A PR bond. He caused a wreck with a 0.4 blood alcohol level. What?
Given the alleged BAC, I think that's appropriate in this case. Not go to any bars or taverns, to not drive without a valid license or insurance, to not consume any alcohol, marijuana, or non-prescribed drugs, to not refuse a UA or breath test when requested by law enforcement. And you are going to be on what's called pretrial services supervision. The paperwork you're going to get at the jail has a phone number for you to call. You have to call them within 48 hours, or the court may issue a bench warrant. Pretrial services supervision will let you know what to do next, essentially. They're the organization that does the scram device. So that's a device you wear on your ankle. And it monitors any alcohol intake in your system. They will help you set that up. A different agency sets that up, but they will help you out with that. So the one organization you need to keep in your mind when you're released is pretrial services supervision. Again, you need to contact them within 48 hours of your release. Okay. The scram device is free. You get that at county taxpayer expense because you're indigent, so that's not something you need to pay for. That may be a different story with the the ignition interlock device. You can talk to DOL about that. I think there are some programs to help folks pay for those, though. Okay. All right. So those are your conditions.
I'm not planning on driving. I wrecked my car the night.
Don't talk about the facts of the case.
Okay.
Okay, thank you.
And if you're not going to talk to you've got a court-appointed counsel. If you're not going to be driving while the case is pending, there's a document you can submit to let the court know that. All right. Last thing, you're going to have a pretrial hearing, and that's going to be scheduled for March 10th at 8:30. All right.
Okay. Yes, sir.
Do you have any questions for me?
No, I don't believe so at the moment.
All right. Good luck to you, sir.
All right. Thank you very much.
Free to be taken back.
Okay.
All right, we are on the record again today for the 28th Circuit Court here in Wexford County, and we're going to continue today's docket call by taking up the case of People of the State of Michigan versus Blaine Morgan Merritt. This is a older file. File number is 15-11280-FH. Appearances from counsel, please, beginning with the AG's office.
Christina Beda on behalf of the Attorney General's office.
No, I'm Jeff Harrison. I'm here on behalf of Mr. Merritt. He's joined me at the table.
All right, thank you. Mr. Merritt has been brought in today. He is currently sitting in custody at the Wexford County Jail. We were here back on January 13th for an arraignment on a requested warrant for a probation violation that included a single count, a count which was issued by, presented to the court by Mr. Stapleton, who is here today from the Department of Corrections. Back on November 21st of 2016 and signed by my predecessor. Again, we've already conducted an arraignment. Mr. Harrison has been appointed. Mr. Harrison, what are we doing today in regard to the probation violation file?
Mr. Merritt intends to make admission to the, I believe it's a single charge,
All right.
single allegation.
Now, if that happens, that would apply obviously only to the original conviction. I do note that this court has been handed another file that has been recently bound over to the court from the 84th District Court. That case number is 26-14192FH. And in it, there is a new felony information alleging another failure to pay child support. And that would have covered a date range from August 1st of 2015 through December 31st of 2016. Do we have any intent or desire to resolve that case today? Yes or no?
We're working on the mechanics of resolving it. We have had the initial conversation with the AG's office with regard to their usual tiered structure.
All right. Thank you very much. And that actually, just to remind everybody, has outstanding arrearages that go all the way out to July 15th of 2019. All right. Mr. Merritt, please raise your hand to the best that you can, sir. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. All right, Mr. Merritt, I'm told today that you're going to plead guilty to the single count on the request and warrant for a probation violation today. If you do so, you'll be waiving certain rights and now have a contested hearing. At a contested hearing, the prosecutor will have the burden of proof by a preponderance of the evidence. Also at that hearing, you will of course be represented by your counsel as well as in any subsequent proceeding. You also would have the right to confront any witnesses, question and cross-examine any witnesses presented against you, review the evidence presented, as well as the right to present witnesses, evidence, or testimony, and the right to remain silent and not have that silence used against you if you chose to do so. Mr. Merritt, do you understand those rights? All right. So, and do you understand even more importantly that if you enter a plea of guilty here in just a couple minutes, that you'll be waiving those rights as they apply to this allegation of violating your probation? Yeah. Now, the single count on this request and warrant for a probation violation alleges that you violated condition 9.02. Actually, there's two counts, aren't there, Mr. Stapleton? No, hold on. I have one. 1 second here.
Was there an amended petition filed?
Well, hold on. Yeah, hold on. Let me explain what I see. There is a motion and affidavit and bench warrant, as I mentioned earlier, signed by Judge Fagerman. On that there's a single count alleging that you violated condition number 3, which requires that you make truthful reports to your probation officer. And more specifically, it's alleged that on November 15th of 2016, you failed to report to your probation agent in order to make any subsequent reports. Now, initially, that's what we call a technical violation. For a technical violation, the court is limited to a sliding scale of 15 days for 1, 30 days for 2, 45 days for 3, or for 4 or more, the court would no longer be limited to that sliding scale. However, based upon the fact that this is an allegation of you being in an absconder status for more than 60 days, in fact, it's almost 10 years, the court it is no longer a technical violation. It then becomes a non-technical violation.
This dude's been on the lam for a decade. They finally got him. His cases are from 2019, I guess, and earlier.
In a situation where there's a non-technical violation, the court is no longer limited to that sliding scale and is only limited by the amount allowed under the law for the original offense. In this case, you were originally convicted of failing to pay child support as an attempt. That makes it a felony punishable by up to 2 years and or up to $2,000. Mr. Stapleton, what I need to know here, and I'm looking back since this is quite an old file, was this part of a delay of sentence?
No, Your Honor, no.
All right, and I was incorrect. It's up to $1,000, not 2,000, but it's still up. It's actually called a high court misdemeanor punishable by up to 2 years. All right. Now, additionally, I see Mr. Stapleton that signed a petition in order to amend probation. Oh, it just says that he is not to use or possess. So that's not actually a violation. I'm sorry.
Okay.
Thank you. All right. So, Mr. Merritt, I'm told you're going to plead guilty to that single count. Again, that you've been in an absconder status for more than 60 days. Is that true? Is that how you wish to do this? All right. Has anyone made any promises, threats, or inducements to force or compel you to admit guilt to violating this probation condition? Has anyone made any promises, threats, or inducements to force or compel you to plead guilty to this violation?
No.
Has anyone made any promises to you as to exactly what the sentence would be from this court? Thank you. As to the single count on the requested warrant for the probation violation, as I previously advised, how do you plead? Is it true, Mr. Merritt, that beginning back in 2016, specifically beginning on or about November 15th of that year, you failed to report to your probation officer and hadn't reported since?
Yep.
All right. Ms. Betta, do you believe the defense provided the factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements I haven't discussed?
No, I am not.
And you believe the court's compliance with the court rules?
Yes. Yes, Your Honor.
Mr. Harrison, do you concur?
I do concur in all 3 points.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further takes judicial notice of the terms and conditions of probation that are contained here in the court file and that were previously signed by my predecessor, Judge Fagerman, and were subsequently acknowledged by they were signed by Judge Fagerman on July 28, 2015.
The cases are so old. They were from a previous judge even. Wait, hey, okay. She got extra. Not spoiled or anything. Not even a little bit.
And acknowledged by the defendant actually a couple of days prior to on July 27th, 2015. The court therefore finds the defendant's plea today is made freely, knowingly, and voluntarily. The court therefore accepts the plea and the defendant is found guilty of that probation violation. Mr. Stapleton, can we proceed to sentencing?
We can, Your Honor.
Any objection to that, Mr. Harrison?
None whatsoever.
And any objection to that, Ms. Betta?
No, Your Honor.
Thank you. Mr. Stapleton?
The defendant was originally sentenced July 27th, 2015 to a 2-year probation term for attempt failing to pay child support. Sentencing guidelines were 0 to 1 month. He was given a sentence of 2 days jail with credit for 2 days served. Currently, the defendant has been in custody for 27 days, so his credit will be 29 days as of today. I recommend that probation be discharged unsuccessfully, preserve fines and costs, and preserve any child support still owed, and sentenced to 29 days jail with 29 days credit.
Oh, so the prosecutor's offer gets him out today. after he hasn't been seen in the court system for a decade. Earlier I said 2019 because they had just said 2019. I screwed it up. It was 2015. I tried backtracking by saying and earlier, but whatever. Everybody's gonna ding me on it anyways. Yeah, a decade.
Ms. Betta, on behalf of the people, ma'am.
We would leave it to the discretion of the court, Your Honor.
All right, thank you. Ms. Betta, can you tell me whether or not you have information as to if he's made any payments on his child support?
He has not made any payments since 2021. His outstanding balance as of the 3rd is $17,505.13.
Thank you. Mr. Harrison, your position?
Oh, I think the recommendation is well reasoned. Obviously, my concern is that he continue to earn credit on the new file, and that arrangement proposed by the department will allow him to do that. I think it's appropriate under the circumstances, encourage the court to follow it.
Mr. Merritt, is there anything you wish to say today, sir? No. All right, before the court is the a defendant who is 48, 49? 49, thank you. Oh, that's right, you just had a birthday back on the 18th of January. All right. Well, the court recognizes that this was an intermediate sanction cell. The court therefore starts with a presumption of probation, fines, and costs and no jail. However, that is at the initial taking of the sentence or issuing of a sentence. This sentence was issued before the modifications in the law that took place and became effective in early 2021. However, the court is concerned here, the defendant has been in an absconder status for more than 9 years. So, and I'm also hearing that the defendant, and I make a finding by the preponderance of the evidence that the defendant is not making payments or not sufficient payments on his child support, and apparently he's thumbed his nose at the court for appearing complying with the orders of the court, and he got a benefit. So the court preserves all fines, costs, and payments for child support. The court terminates supervision without improvement, and the court sentences the defendant to 180 days in jail with 21 to 29 days of credit. I find that there are reasonable grounds for that sentence. Specifically, he's been in an absconder status for such a long time. I don't know why I wouldn't do anything. Plus, I find that there are it's reasonable proportionate. He's been on the run for 9.5 years. So that's the sentence of the court. Yeah, father, children, you've got responsibilities for them. You take care of them. And you got a benefit last time, and you didn't take care of your obligation. Ms. Nyman's going to provide to Mr. Harrison 2 copies of one document. You're going to place your initials on it and on one copy, and the other copy you're going to take with you. This document tells you that you have the right to appeal the conviction and sentence in your case. And that is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal.
I don't know. I think him having to serve 160 days is kind of refreshing, considering they wanted to let him out today. The judge was like, no. No, you're not going home today. You're serving time for this. Love that judge.
If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Have I missed anything, Ms. Betta?
No, you have not, Your Honor.
Thank you. Mr. Stapleton?
No, Your Honor, thank you.
And Mr. Harrison, I see is returning that initial copy to the court.
I am. I'm
Okay.
fully satisfied with the record. Thank
All
you.
right, thank you. We're adjourned.
Thank you.
Calling case number 25, P Lake Parking 298888. This is People versus Antonio Patrick Gagnon.
Pretty good, yes.
All right. I was just watching a BBC history, and Shannon came on, and so it's sort of the French thing is sort of on the court's mind at the moment. So.
Oh yeah, I have a very famous grandfather that was held up the flag of the team.
Oh, Gagnon. I'm getting that right.
Yep. You got it.
All right.
Maybe he spent time with the guy we watched earlier that was, royalty and high and mighty and biblical.
Mr. Gagnon, you were present earlier today when the court explained the nature of an informal hearing. True?
Yes.
Yes. So you were also understanding that you must select from one of three options to protect your rights, correct?
That is correct.
Thank you, Mr. Gagnon. The citation before the court concerns a parking episode from November the 15th of last year. At exactly 3:03, a vehicle plated to you or a householder was parked on Main Street at or near 417 South Main. Remained there until 5:23. So total park time, 2 hours, 20 minutes, 10 seconds. However, there's no record of a deposit of funds made and therefore no purchase time. So the citation is a non-moving 0 overtime at meter, maximum possible fine, $20, minimum 0. You may admit responsibility today. You can admit and explain, or you can deny responsibility and conduct your trial. What do you wish?
I will deny.
Very well. Please raise your right hands. You both solemnly swear the testimony you shall give before this court shall be the truth.
I do.
Thank you very much. The officer has the burden. Then it's your turn, sir.
Good afternoon, Your Honor. Ticket number 298880, plate RIG08. Date of offense was 11/15/2025. Was parked at meter 1812 on South Main Street. They parked at 3:03 p.m. No time was purchased. They drove away from the meter at 5:23 p.m., which had them in violation for parking at 2 minutes and 5 minutes. We're minusing the 15 minutes that the city of Royal paid for. On this day, I checked this. All systems were up and running. Cars behind them and before them paid for parking. I am the officer of Royal Parking Authority. You know how to run the schedule to check to make sure that payments were being received. If we had any issues, dispatch will contact us and let us know if anything went out of order that day, any meters, nothing of that such had happened on that particular day.
Okay. Thank you very much, Officer Rucker. And now it is your turn, Mr. Gagnon. What would you like the court to know?
Yes, I know it's only $20, but I was meeting a client. So I got an echo here. I see my name's on here twice. I don't know if I should close this out.
I can boot the one that's not broadcasting right now.
Okay.
And there it goes. Okay.
Oh, so much better. Thank you. Okay. Yeah, so when I pulled into that spot, there was about an hour and 45 minutes left from probably a previous person who parked the vehicle. And I had about an hour and a half meeting with my client at the coffee shop. So I walked inside, I set an alarm on my phone to come out just in case I was going to be a little longer. And when I came out, I set my alarm, came out, I had about 10 minutes in. I put, I think, 2 quarters in there, which gave me another half hour. I went back inside to finish my meeting, came back out to leave. I still had some time on there. I don't recall the time, it was so long ago now, but I believe it was around 3 or 4 minutes, which is what I set my alarm for. So and then I discovered when I got in my vehicle that I indeed had a parking citation on my windshield. And that's the truth. Did I use somebody else's time when I got there? Absolutely. But I didn't think I had to put in if the meter was still going.
Okay. Is there anything else you want the court to know, Mr. Gagnon?
No, that's it. If I was at fault because I didn't put anything in the beginning, then I admit responsibility, but I tried to like piggyback on the time that was already there.
All right. There may or may not be some rebuttal testimony that
Rebuttal,
shines a
please.
light on that. Go ahead, Officer Rucker.
I think this only works at a laundromat, sir.
So you can't take someone else's time because once you pull out, once that person pulls out and you pull in, the cameras reset. So you wouldn't be able to use someone else's time. And maybe you paid for the wrong meter when you put in your 50 cent time in, but there was no time for that meter at all. And it's the auto sites. I do apologize for the auto sites.
So what she's suggesting, Mr. Gagnon, is the best analogy the court can fashion is similar to an airline ticket. You can't just show up at the gate if the ticket's in somebody else's name. Similarly, the system, the MPS system that is no longer in service at this time, its service history is over. Those bollards are positioned at the back of the vehicle and take a photograph of the license plate. Also, the kiosks are not space specific. So there may have been some misapprehension there, but in any event, the court has heard the testimony of both parties in People versus Gagnon. The court notes first that the burden of proof in a civil case is a mere preponderance of the evidence. And secondly, the court believes both parties are proceeding in good faith based upon their best recollection and perception of the events. The court is finding you responsible, Mr. Gagnon, but based on your professionalism and your honest error, the court reduces this fine to $10. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30, due within 14 days. And there is a new system in town, so if you hit that coffee shop with your client again, there is a new system to learn, but it is relatively simple.
Okay, I appreciate it. Thank you.
Thank you. Calling case number 25, P like parking 305-744, People versus Jennifer Marie Ertman. That's you?
Yes, sir.
Ms. Ertman, today is the date and time for your informal hearing. You were present a little bit ago when the court explained that process, correct?
Yes, sir.
So you understood the court to instruct that you must select from one of three options to protect your rights, correct?
Yes.
Thank you, Ms. Ertman. The citation before the court was issued regarding a parking episode from November 22nd of last fall at exactly 5:16. A vehicle plated to you or a member of your household entered a slot off of 5th Street, remained there till 7 o'clock. Total park time, 1 hour, 43 minutes, 5 seconds. However, there's no record of a successful deposit of funds and therefore no purchase time. So this is an overtime at meter citation. It is 0 points, non-moving, maximum fine 20, minimum fine 0. You may admit responsibility. You can admit and explain, or you may deny responsibility, and we will swear the parties and take your testimony. What do you wish the court to do?
Well, I would like to deny
Very
responsibility.
well. Please raise your right hands. Do you both solemnly swear the testimony you shall give before this court shall be the truth?
Yes, Your Honor.
Yes.
Thank you very much. The officer has the burden. Then it's your turn, Ms. Ertman. Officer Rucker.
Good afternoon, Your Honor. Ticket number 305744, plate number 9MRE22. Date of offense was 11/22/25. They were parked at meter 1801 on East 5th Street at 5:16 p.m. No time was purchased. They drove off at 7 o'clock p.m. and they had them in the violations for 1 hour and 27 minutes. That's minus the 15 minutes that the city of Royal Oak pays. Doing the research, of looking up to make sure, because I normally do this, I go in to make sure that maybe they maybe pay for the meter before or after, because sometimes people get the meter numbers wrong. I did see that meters were paid in front and behind them. With nothing was paid for 1801. I checked, even sometimes people they make mistakes and they try to use their plate numbers. I went in and I checked that. It was nothing in there. It was no time purchase on that day. The system was running. Dispatch had not had us go out to do any services or to take the meters offline or anything like that. I'm trained to go through the system to see the payments, meters being down, to even verify with dispatch to see if we had any calls for that meter on that particular day, and nothing was done. So everything was working fine that day.
She takes her job very, very seriously. That is some thorough detective work, Ms. Rucker.
Thank you, officer. So you are a regular keeper and custodian of business records for the parking enforcement system through MPS, correct?
Correct.
Thank you. Ms. Ertman, what would you like the court to know?
Yeah, I agree with what Ms. Rucker is saying. My husband and I went to dinner that night. We parked the car, went to Hopcat, and then we left. I can see in my transactions that yes, no payment was made. However, I do have the concierge set up in the app. And I'm looking at my transaction list here. I've never had a problem with the concierge service not working until that night. And the app failed. I had $21 in my account, and I can show you a print screen of the app. It has my plate number, which is correct. I had money. I'm not trying to skirt paying. I'm always happy to pay for parking. I know it goes right to the city, but this is a failure of the app and not of me.
Okay.
So.
Are you able to share your screen with respect to the, I believe you said concierge service?
Yeah, so I can show you, let me see here. Share my screen. Okay.
All right, you're live. Good.
So this is a list of all my transactions since the app was launched in 2023. You can see that I use the concierge regularly. It's never failed me until the day of November 22nd, was it? There was no payment made. You can see that, but you can see the concierge has always worked until that day.
Okay. It looks like it gets more recent because right now I'm just looking at, it looks like 2023. Can you move it down a little bit? Oh. It ends. Okay. Because yeah, the most recent date is 2023.
Okay, the app is failing me again. It's not showing everything. I do have showing in the app that I have $21 in funds and it's linked to my license plate number if you want to see that.
If you can do that, that would be helpful because what the court's looking at right now is 2.5 years old. So that's not really germane to the parking episode from last fall.
I'm sorry,
You're fine.
Yeah, let me see.
Officer Rucker?
Yes, I believe that Century Mobile sent out emails the end of October, the beginning of November, letting all customers know if they had concierge service that they were no longer to be able to use that come the beginning of November because we were ending our contract with them December 31st. So we were moving over to our new system. So they emailed all the customers letting them know because people were not able to add more money onto their accounts or anything.
After. All right, but we
where it
wouldn't know if MPS misdirected their email if it came back mail or Damon, because we're not MPS. Correct, officer?
Yes.
Aww, how sweet of Magistrate Yerk to try to find a legal loophole to get this gal out of trouble.
Okay. Thank you very much. All right. We were technically on Miss Ertman's testimony. Miss Ertman, is there anything else you want the court to know?
No, just that I'm a law-abiding Royal Oak citizen, and I believe that the app failed me.
All right. You're doing fine. Obviously, we're not here on bank robbery or murder, so
I
everything's
know.
good. Ms. Ertman, the court believes you were proceeding in good faith. The court makes a finding that the burden of proof has been met. So the court does find you responsible, but the court also believes that the ends of justice augur toward 0 fines and costs. So you owe the court nothing.
Okay.
All right.
Thank you. I appreciate that, sir.
Good luck to you. Take care.
Okay. All right. Bye-bye.
Calling case number 25, P like parking 285364. This is People versus Jessica Aaron Faber. That's you?
Yes, Your Honor.
Ms. Faber, you were present earlier this afternoon when the court explained the nature of an informal hearing. True?
Yes,
So you understood the court to instruct that you must select from one of 3 options to protect your rights. Also true?
yes.
Thank you, Ms. Faber. This citation before the court indicates that there was a parking episode on Halloween at exactly 2:42 p.m. A vehicle plated to you or a household member was parked at Center Street, exited that space at 4:34. Total park time 1 hour, 51 minutes, 37 seconds. Your paid time plus free time was actually 1 hour and 39, and that included 15 minutes purchased by the city of Royal Oak. So technically, you are overtime at meter for that amount of time. Stay with me for just 1 minute. Your purchase of $1.75, which the court acknowledges, obviously, technically purchased you 1 hour and 24 minutes, and then the city of Royal Oak purchased an additional 15 minutes. So your overtime at meter, not terribly so, but that is at least the allegation before the court. Ms. Faber, you may admit responsibility. You can admit and explain, or you may deny responsibility and will swear the parties and take your testimony. What do you wish the court to do?
That was me driving, so I admit that was my car. I have an
Okay.
explanation, however.
Okay, well, you can provide your explanation, absolutely, but you have to do so within a context. So before the court can take an explanation, it needs to know which of those remaining 2 avenues you are using. So you can admit and explain, which means you're technically taking responsibility, or you can deny responsibility and explain under oath after the officer testifies.
So I'm not sure what the ordinance states, so I can't state if I'm
Okay,
admitting
that's
to
fine.
the ordinance.
Please raise your right hands. You both solemnly swear the testimony you shall give before this court shall be the truth.
Yes, Your Honor.
Thank you very much. Officer Rucker, please proceed, and then it will be your turn, Ms. Faber.
Good afternoon, Your Honor. Ticket number 25364, plate number ETE2927. Date of offense, October 31st, 2025, was parked at meter 908 on South Center Street. They parked at 2:42 p.m. They made a purchase at 2:45. They made a total purchase. They paid $1.75, which gave them 1 hour and 24 minutes. The city of Royal Oak paid for 15 minutes. They moved away from the meter at 4:34, so their total time parked was 1 hour and 51 minutes. They were in violation of 5 minutes and 21 seconds. So it was just 5 minutes. So a nickel or a dime would have been suffice, and they would have been made whole if they paid at the end of their session. So if she came and saw the red light, she could have paid a nickel or a dime, and she would have been fine.
Okay. And your testimony is derived from your position as one of the regular keepers of records and custodians of records for the Royal Oak Parking Enforcement Office. Is that correct?
Correct.
Thank you. Anything further?
No.
All right. Ms. Faber, it's your turn. What would you like the court to know?
A few things, Your Honor. One, I was in the vehicle I wrote a letter to the city. I was in the vehicle with my daughters. We went to Starbucks, which was right next to where I parked. It was raining, close, maybe sleeting or snowing. We got the coffee and hot chocolate with my daughters, went into the car and sat in the car because we couldn't walk around anymore because of the weather. So I was in my vehicle at the time it expired. Respectfully, there was no parking attendant there to approach the vehicle. It's a video camera. So all of the testimony is based on not any foundational testimony by the parking attendant, because the parking attendant was not there to know whether I was in the vehicle at the time that the meter expired.
You know what's more reliable than a parking attendant? A camera that digitally logs all of the time that you stayed in that space. Does it matter that you were in the vehicle? Your car was still physically taking up a spot. That's what you're paying for. Whether you're in it or not, it doesn't matter. You are still parked there. And whether the parking attendant made an appearance or not also doesn't matter, because the video and the timestamp show that you were there. Sorry, I was trying really hard to get her cadence down. How'd I do?
So I guess a few things. One, I was in the vehicle. So if a parking attendant came up to me and said, your time has expired, here's a ticket, I would have left. Two, I do think these cameras, and I'm sure you get these complaints, but from everyone, are unholy unfair, because you don't have no idea what's going on with the people parking and the people using the stores in Royal Oak. You want to encourage people to use those stores. I went to Starbucks, I'm purchasing things from your city, and you don't even have parking attendants walking around to enforce these ordinances. You have a camera that takes photos, that generates a ticket.
Okay, I don't mean to interrupt you, but I want to just make certain that you understand, because you're obviously an educated woman. You are using the pronoun you. This court is not the city of Royal Oak. This court actually sits and has jurisdiction over Royal Oak and Berkeley. Court is not a party to this case. So please proceed.
Understood, Your Honor. So I guess Miss Rucker, is the representative of Royal Oak. So two things. One, I was in my vehicle. I purchased from Starbucks with my $2 in the car. In my vehicle, it was raining and sleeting. I was there when the time expired. So if a parking attendant had come to my vehicle, I'm old enough to remember parking before cameras are taking photos of meters, and that is a common thing. I think that these cameras are wholly unfair, because I had no idea that my time expired while I was in the vehicle, because I have a van and I can't see the light when it goes red. I can't see them take a photo. If someone walks up to your car, knocks on the window, I can see attendant, oh, sorry, I didn't realize my time expired. We're in here drinking our coffee because it's cold outside. I'll drive away. No ticket. you know, so it really does discourage people from going to Royal Oak, to be frank. I think that so that's what I'll leave it at that and let, you know, I don't think Ms. Rucker, she definitely wasn't there to know anything to dispute that. It's all based on a camera that regurgitates the information that is being relied upon.
Okay. Is there anything else you want the court to know?
That's all, Your Honor.
All right. Any rebuttal testimony?
Oh, what a Karen. Having parking enforcement really discourages people from coming to your city. If only you'd get rid of the parking meters with video and stop catching us doing things wrong, then we might be more encouraged to come spend money in your shops. You're gonna win this one, lady.
Yes, Your Honor. So whether or not a park attendant was out there or not, it's Michigan law, not Royal Oaks law, but Michigan law. There's no stop and stand, and if you're parking in your vehicle, you're in your vehicle and you're parked. So you have to pay for parking. That's the rule. That's Royal Oaks rule. You could have extended your time if you wanted to sit there.
Move away from the you pronoun and just.
Oh, well, I'm sorry.
Okay.
Time
You're doing fine.
extended if the customer wanted to sit in their vehicle and drink their coffee. There's no rule against that. There's 3 hours minimum. 3 hours maximum. On the 3 hours maximum for street parking. So 3 hours could have been paid for, and the customer could have sat in the vehicle and drunk their coffee. Had a parking attendant or an enforcement or a enforcer or officer came up to the car and saw that the time was expired, you would have received a ticket. Not just you just drive away, you would have received a ticket. So either way, the time was not paid. It was 5 minutes. The 5 minutes could have been paid for.
Thank you. The way this works, Ms. Faber, is the party with the burden of proof actually testifies first, and that has occurred. The responding party, that's you, testifies, and then the party with the burden under the civil rules of procedure and evidence is permitted for rebuttal. The court has heard the testimony of both parties in People versus Jessica Aaron Faber. The court first notes that the burden of proof in civil proceedings is a mere preponderance of the evidence. And the court believes that both parties appear to be proceeding in good faith based upon their best recollections and perceptions of the event in question. The court first notes that a foundation was laid respective of Michigan Rule of Evidence 803 as relates to the business record exception. The officer was qualified on the record as a regular custodian of records. The court would also note that indeed, sitting and standing are the same as parking with respect to both the specific Royal Oak ordinance as well as corresponds with Michigan compiled law. And the court understands the public policy argument, i.e., nobody likes these cameras, nobody likes enforcement of any kind. But we could take that not even too terribly of a step further to say people don't like speed limits either. At this juncture, Ms. Faber, the court will find you responsible. The fine in this matter is $20. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days, but you may also perfect an appeal by posting a $20 bond within 7 days. The matter gets placed on the formal hearing docket, and at that time, the city of Royal Oak would be represented by a city prosecutor. So 20 as a bond or a fine within 7, and that completes your hearing. Thank you for your patience.
Thank you.
Oh, she got no grace. She got no discount. The judge held her fully accountable. I love it.
Hello.
Hello. Are you also listed as direct?
Yes.
Thank you. This is case number 25, P like parking, 302-922. People of the city of Royal Oak, as captioned, Amanda Lee Direct. How do you wish to be addressed today?
Amanda is fine.
Well, I mean, hey, how or direct?
Hey, how?
Ms. Hayhow, you were present earlier today when the court explained the nature of an informal hearing. True?
True.
So you also understood the court to instruct that you must select from one of three options to protect your rights, correct?
Correct.
Thank you, Ms. Hayhow. The citation before the court concerns a parking episode from November 20th of last year at 9:56 a.m. A vehicle plated to you or a member of your household entered a slot at 3rd Street, remained there till 11:19. The total park time was 1 hour and 23 minutes, 4 seconds. Officer Rucker, remind the court when enforcement commences.
Commences at 11 a.m.
Okay. So if your vehicle left at 11:19, technically, obviously without a deposit, while you were parked for 1 hour and 23 minutes, your quote unquote requirement for paid time would have been plus or minus 20 minutes. So this is an overtime at meter citation, 0 points, non-moving, maximum fine $20, minimum 0. You may admit responsibility, you can admit and explain, or you can deny responsibility and will swear the parties and take testimony. What do you wish the court to do for you?
I will admit and explain.
Very well. So you're confirming to the court that on the date in question, you did in fact park or keep stationary a vehicle in the city of Royal Oak that was mildly unpaid for parking time, correct?
Correct.
Thank you. What would you like the court to know, Ms. Hayhow?
I was going to my therapy appointment in that building. They had let me know that parking is free until 11 a.m. So after I got out of my appointment, I was just sitting in my car, making sure I was mentally safe to drive after my emotional appointment. I did not think anything of feeding the meter for the 20 minutes that I sat there.
Thank you, Ms. Hayhow. The court appreciates your earnestness in this matter. The court has one question that is entirely unrelated, which is, it looks like you're a chef.
Yes, yes, I am
Okay.
currently at work right now.
All right. Well, when the court sees something like that, especially at this hour, and since the court was at its PT over lunch, you're just making us hungry.
I love how the judge says you're just making us hungry. As a moth or flying bug of some sort makes its debut appearance, I'm no longer hungry.
Ms. Hayhow, the court appreciates your candor, and at this time, the court's going to waive the fines and costs in this matter.
Okay, great.
Good luck to you. Get back to dinner.
Thank you very much.
Bye-bye.
And get that bug. Go get that bug before it gets on the food.
State of Kansas, James Watts, Defense Counsel. Defendant Crumrin appears from the Butler County Detention Facility Zoom location. This matter comes before the court at this time for a scheduled evidentiary preliminary hearing. What announcement is made at this time, Mr. Watts?
Your Honor, after discussion with the state, it's my understanding my client would plead guilty to count 2 of the information, possession of methamphetamine. That's a simple possession. The state would dismiss the remaining counts. At time of sentencing, Your Honor, we are confident he will fall on a presumptive probation box. And I say that because he was sentenced in another case only 2 days ago to the very same offense. He was a C on the grid. In that matter, he is going to be a C on the grid, likewise in this matter. Indeed, they've already done the drug and alcohol evaluation and assessments that are necessary. They may not need to be done again. given he was sentenced in that matter only 2 days ago.
Mr. Sweeney, has Mr. Watts announced consistently with your understanding as to how this case would be handled?
That's accurate, Your Honor.
Mr. Crumrin, you've been present when your attorney made an announcement. He says that you want to resolve your case today by entering a plea apparently of guilty to count 2, possession of methamphetamine, a level 5 drug felony. Is that indeed your intention?
Yes, sir.
All right. It's of course understanding then, Mr. Crumrin, that you're waiving your right to a preliminary hearing in the case and instead proceeding with case resolution through plea. I've got a number of questions I need to ask you regarding the taking of a plea of guilty. If there's anything you don't understand along the way, I'll give you the opportunity to confer privately with your lawyer, Mr. Watts, at any point. Just let the court know if you need that time to get some more advice, okay?
Yes, sir. Yes, sir.
State your full legal name for the record.
Richard Robert Crumrine,
How old are you right now?
42.
What's the highest level of education that you've attained?
I've got a GED, 11th
Do you
grade.
believe you're going to have any difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
No, sir.
He is my age, guys. That guy is my age. And he's got a GED. You know what that means? A good enough diploma.
Have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
No.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking mental health meds that you are not currently taking?
No, sir.
So do you believe your mind is clear and that you have a full understanding of what's going on here in court?
Yes, sir.
Do you understand the nature of the charge in count 2, possession of methamphetamine?
Yes, sir.
You understand that when you enter a plea of guilty, you are admitting that very act that's been charged by the state?
Yes, sir.
You also understand that you would be waiving any legal defenses that you might have had to that charge, particularly any suppression motion that you might have been able to pursue in this case. You'd be waiving that.
Yes.
All right. Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, and that you could present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to get up on the witness stand under oath and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, sir.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, sir.
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial?
Yes.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes, sir.
Are you aware of the possible penalties that could be imposed as a result of this guilty plea that you are attempting to make?
Yes, I do.
You'd be on level 5 of the drug grid. In the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. We do not know with absolute certainty what your criminal history will be at time of sentencing, Mr. Crumrin. That will be researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that will determine where you fall along the level 5 drug line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
Mr. Crumrin, do you understand that if you have a person felony on your record at time of sentencing, you would be presumptive prison in this case?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for this offense?
Yes, sir.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders.
Yes, sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate by the court at time of sentencing.
Yes, sir.
Do you also understand that both probation and post-release supervision periods, which is your state parole time that you do after you get out of prison,
Yes.
will be at least 12 months in duration, but can run up to 60 months under some circumstances?
Yes, sir.
You understand that if any special sentencing rules apply to you at the time of sentencing, it could affect your eligibility for probation or otherwise affect your sentence.
Yes, sir.
Now, did you have an ample opportunity to fully discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Yes, sir.
You want any more time with Mr. Watts privately now before we go any further?
No, sir.
Are you satisfied with the services and advice given to you by James Watts?
Yes, sir.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No.
You understand, sir, that if there have been any plea agreements between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. You understand that?
Yes, sir.
So let me ask you, how do you plead to the charge in count 2, possession of methamphetamine, a level 5 drug felony?
Guilty.
All right. According to the state's charging document, this took place on or about November 25 of 2025. Is that when it happened?
Yes.
It happened somewhere in Butler County, Kansas. Where was it?
Augusta.
Okay. And were you in possession of the controlled substance methamphetamine on that date?
Yes.
Where was it?
It was in my truck.
Did you know it was in your truck?
Yes.
Did you know it was methamphetamine?
Yes.
Do you have the legal right to possess methamphetamine in the state of Kansas?
No.
So do you now freely, knowingly and voluntarily enter a plea of guilty and accept conviction for possession of methamphetamine, a level 5 drug felony?
Yes.
All right. Mr. Sweeney, do you know of any legal reason why the court shouldn't accept this defendant's plea?
I know of none, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Mr. Crumrin, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea of guilty today?
No.
Court will accept the guilty plea made by the defendant and finds that that plea is made voluntarily. He has an understanding of the nature of the charge against him and the consequences of the plea, and the court will therefore accept his plea of guilty and find him convicted of the crime charged in count 2, possession of methamphetamine, a level 5 drug felony. All other charges of the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine the defendant's criminal history, and the court will set an appropriate date for sentencing. I may be a little bit optimistic here. Mr. Watts, you represented, he may have pretty much a completed pre-sentence report done recently.
He does, Your Honor. The previous report was submitted February 3, about 11 days ago. I take that back, 9 days ago. My math isn't that good. So it's very recent. It includes a substance abuse evaluation, as all of them do, as well as the LSIR, LSCMI. He qualified for Senate bill on that one, so.
Counsel, would you check your calendar for Monday, March 30? Now, I know, Mr. Watts, you and probably even Mr. Sweeney would have afternoon docket responsibilities, but I'd be looking at 10 o'clock a.m. for this one.
March 30?
Yes?
Yes, sir. I'm in front of Your Honor at 9. I could do 10 o'clock. Yes, sir.
Very well.
I have, sir, I have court for a driving on suspended ticket that day. I don't know what time the court is, though.
9 o'clock, probably.
It's for Webster.
Yeah.
Are you represented by Darren Patterson on that case?
Yes.
Well, I'm sure Judge Webster would understand that if you have a felony sentencing, that maybe you need to be taken early in that docket rather than later.
Ooh, he's going up against a Webby. I don't know, on the 30th, we might have to have a dual hearing. Webby versus Ricky. I think that'll be a fun one.
Especially since Mr. Patterson will be visiting with his clients generally well before 9 o'clock. I'm going to go ahead and leave it where I suggested, counsel, 10 o'clock a.m. on Monday, March 30.
Yes, sir.
The court orders the defendant to completely comply with any pre-sentence assessments that may be necessary. I think you maybe even went through those recently. Mr. Cromrine, risk needs assessment, substance abuse assessment, you may be asked to do those again. You'll need to fully comply with those.
Yes.
Sentencing, Monday, March 30, 10 o'clock a.m., contemplated to be done by Zoom. If the defendant makes bond, he is ordered to appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location for sentencing. You understand that, sir?
Yes, sir.
Okay.
Is there
anything else we need to address, Mr. Sweeney?
Sorry, Your Honor, nothing that I'm aware of.
Mr. Watts, anything further?
Judge, the only thing that I think about considering this is, given the circumstances, he was granted probation on an earlier case by Judge Satterfield as a Senate Bill 123 case. I'm confident, given the circumstances, he's going to fall in exactly the same place in this case.
He's seeing all the Kansas favorites. Satterfield, Ricky, Webby. I bet you anything he's also been in front of Judge Hart and that one out of Elk County.
And given that reality, and given that she's already placed him on probation in that case, it might make sense to modify his bond so he can begin that probation as well as participate in whatever evaluation need to be done here. Current bond looks like 15,000. Perhaps even just convert that to an OR. Even it would be a fairly high OR, but it would be sufficient to get him out and get this process started.
Mr. Sweeney, does the state take a position on the request?
Your Honor, kind of maybe a centered position here, but I don't have an objection to maybe a slight modification given the amendment of the charges and the fact that he is on some sort of supervision, obviously with community corrections. That being said, in a felony conviction now, I always like to have somebody that's on the hook to essentially go and get him if he doesn't show up. So while I may not object to a modification of the dollar amount, I'd like to see a cash surety still.
Understood. I understand your position, Mr. Sweeney. Mr. Crummer, if you were to be released on bond, do you have a place to go live?
Yes, I do. With my parents.
Where?
With my parents.
Where are your parents?
What? Rosario. It's 10 miles east of here.
Okay. Now, do they know that would be
Yes.
your intention?
Yes, they know. They are fully aware of it. They're watching this court right now to find out so they can come pick me up with or whatever.
All right. There has been a substantial material change in the status of this case since the time that bond was last reviewed. The defendant had previously faced a presumptive prison offense. He no longer faces a presumptive prison offense. Mr. Crummer, I'm inclined to give you a chance. The court will convert your bond to OR. So if you don't have other holds on you right now, you can be released today.
Yes.
You're signing an execution of an OR bond in the amount of $15,000.
Yes.
Just understand that OR means you don't show up for court. Judgment could be taken against you for 15 grand.
Yes, I'll be here.
You cannot let that happen.
Oh, no, I'll be here.
All right. Furthermore, if you're asked to do anything on the pre-sentence investigation, you need to make sure you immediately get on that.
Yes.
As far as any new assessment that is required for this sentencing. Even if you
Yes.
think you've already done it before, you may be asked to do something again.
Yes, sir.
Furthermore, I need you to make personal contact with the Court Services Department today.
Yep. I'll
You need to go to Court Services and ask them, what do I need to do for this pre-sentence investigation? And then
Yes.
follow
That's
their
it.
direction.
That's in the courthouse, right?
Yes, it is. The
Yes, okay,
judicial
on the first floor? Okay, yep, I'll be there
Yes.
today.
Okay. Further, it does appear that you've been placed on community corrections.
Yes.
As a condition of bond, you must make contact today with the community corrections office as well.
With
So
Ed
you got to see
Ketley.
court services
Yep.
and you got to see community corrections
Yep.
today.
Yep.
Mr. Crummer. Okay. Because you got to get started on that probation in
Yes.
person and get on a reporting schedule.
Yes, sir.
Furthermore, there'll be a condition that you live with your parents in Roselia.
Yes.
No other place until sentencing, and then we can talk about what else your plans might be. But
Yeah.
I feel better that your parents are going to remind you to take care of
Yes.
things.
I hear his mom makes a mean lasagna.
And to get you to court, and you have a place to live here in Butler County.
Yes, sir.
Okay. All right. Any questions about the court's bond modification orders, Mr. Crummer?
No, sir.
Mr. Watts, is there anything further we need to address in that regard?
No, sir, not at this time.
Mr. Sweeney, anything further?
No, Your Honor, thank you.
Is there a representative from the detention center that has heard the court's modification order?
Yes, sir. I've written it all down and I'll be getting it to booking.
Fantastic. All right. Give him a little time to get your process out, Mr. Crummer. But remember, you got a couple of stops you need to make today.
Yes, sir. First on the list.
All right. Giving you an opportunity here. I hope that you will seize that opportunity, make sure everything goes well, and you show up for sentencing ready
Yes,
to
sir.
go as the court contemplates.
Yep.
Okay?
I'll be
All right. Very good. If there's nothing further at this time, then the Richard Robert Crumrine matter will currently be in recess. This meeting may be ended for.
The other booth is a Lacey matter. Attorney Alter, sir, there at the Lacey booth, what's your name?
Dayton. Dayton.
Dayton, okay.
C-A-T-O.
Caton, I'm sorry. Michael Caton?
Yeah.
Mr. Caton,
Yeah.
and
I
Attorney
can
Alter,
handle that if Mr. Ruiz is going to be in the breakout room.
all right, thank you. All right. And Mr. Caton, looks like we're here for an arraignment. In one moment here. All right.
Now I'm seeing this all in minutes. Mr. Tate's name. All right.
Yes, we'll accept that amended complaint. Correcting Mr. Caton's name. So, sir, your name, Michael Edward Caton?
Yes.
Date of birth, February 15th, 1984?
Yes, sir.
Sir, we're here for an arraignment on one count criminal trespass first degree, one count of obstructing a police officer, and third count obstructing providing material statement. Have you had a chance to speak with an attorney today?
I talked to somebody this morning, or like right before this.
Attorney Alt, I'll turn it over to you.
Thank you, Your Honor. He did speak to Mr. Ruiz this morning. We are asking the court to enter a plea of not guilty at this time.
Thank you. All right, Mr. Canton, I will enter a plea of not guilty to those charges.
Okay.
And Attorney Alt is Mr. Canton seeking court-appointed counsel.
Yes, and I believe he qualifies.
All right, sir. So I'll appoint Pacific Point Defense to represent you, their court-appointed counsel for the city of Lacey.
Okay.
All right, to represent you.
All right.
And Attorney Alt, do you have a position on probable cause?
No, Your Honor.
Is that... did he get axed in his forehead? Or is that from furrowing his brow constantly? I can't tell if it's a scar or if it's just I'm a grump face.
We can stipulate to that.
Okay. All right. So, Mr. Canton, what we're going to do next is I'm going to turn to the attorneys for their recommendation on pretrial release conditions. All right. I'm going to start with the prosecutor, Mr. Sharp.
Thank you, Your Honor. The names of the charges here don't convey the seriousness of this incident. The city is asking for $1,000 bail while abiding behavior. Mr. Caton not possess any firearms or dangerous weapons, and they not have any contact with This is the street, this is the residential address, Your Honor. It's Andrew Street Southeast. That request is, well, really based on both prongs of Rule 3.2. Flight risk is there. Mr. Caton does have warrant history. He has an active warrant out of Church. That's Snohomish County Cascade Division. That's new one for me. Additionally, he had DOC warrants at the time of arrest, gave a false name when officers first contacted him and then ran. It's a logical assumption that those warrants had something to do with this. He has had contact with his DOC officer who mentioned that he should be serving EHM for a DOC violation on a failure to register case. So we have flight risk, but probably more importantly, the city has concerns of community safety and potential for further violent crimes. Mr. Caton's record is germane here, Your Honor. He has extensive criminal history, many convictions. Most concerning of which is old but very serious, rape of a child in the 3rd degree. That's 2001. Since then, he's had many convictions for failing to register as a sex offender, as well as other violent crimes. And that's germane because of the facts of this case. In this case, he's alleged to have followed a juvenile to the juvenile's home. There's video evidence of this. And as the juvenile was trying to get into his home and close the garage door, Mr. Caton's alleged to have gone under a closing garage door. I think the officer phrased it as laying down on his side to roll under the door. With that criminal history, even though this is on paper a trespass first, the city believes it's a much more serious matter for the community than the name would portray. City believes that a minimum of $1,000 would be appropriate here. City makes that request believing it's reasonable, understanding that his means are limited.
Thank you, Mr. Sharp. Attorney Alt?
And Mr. Caton has lived in Washington his entire life.
It was a setup, you say, sir? You're on camera following a child and then ninja rolling under a closing garage door like you're some kind of movie star. What part of that is a setup? You creepy wood chipper deserving creature.
He has family that lives nearby in Yelm. His children reside in Lacey. He's on medically assisted treatment program right now on Suboxone. So for that reason, we are asking for PR release.
All right, thank you. Mr. Canton, I do believe that bail is appropriate in this case. I'm going to impose $1,000 bail. I believe the presumption of pretrial release for misdemeanors is overcome, given the factors in 3.2 that there's a showing of substantial danger to community safety and potential issues with the administration of justice, given some of your more recent criminal history. And so I believe that presumption is overcome in this case. So I will impose $1,000 bail. If you are able to post that, conditions of your release are to not commit a criminal offense, possess a gun or dangerous weapon, and have no contact with the residential address or the address provided by the prosecutor, Andrew Street Southeast in the city of Lacey. That address will be provided to you on the judgment sentence release order that will come over to the jail with those conditions. I've appointed the public defenders to represent you, so you'll have counsel. Next thing we're going to do, sir, is set a pretrial hearing, and that's going to be on March 10th at 8:30. Thank you, sir. You're free to be taken back.
Tell us how you really feel. You cockroach of society.
All right, there at it says titled Nisqually third room. If you're able to see that on your end, what
Oh my. This one just looks like a cockroach.
is your name?
Wyatt Matthew Ingram, sir.
Thank you.
Yes, Your Honor, Jennifer Lamari on behalf of Mr. Ingram.
All right, thank you. All right, good afternoon, Mr. Ingram. It looks like you're here for a first pretrial.
Yes, Your Honor, we're on for an agreed change of plea. The court should have received that as well.
All right, thank you. All right, and it looks like the change of plea is in matter ending in 111. All right. And
yes, Your Honor.
The city moving to dismiss matter ending in 715?
That's correct. The city's going to be moving to dismiss that without prejudice on plea to 2026-111.
All right, thank you.
Why would that be without prejudice?
Because that's usually what I say.
I mean, we're making a deal. The deal isn't that you can recharge it later, right?
Well, if he fails on his probation conditions.
If we don't have an agreed recommendation, we're not going to have negotiations here on the record.
I'm just clarifying, Your Honor, because I don't believe I don't think we've ever had it dismissed without prejudice as part of an agreement, so.
All right, well, we can keep this as a pretrial and let y'all keep negotiating.
Well, Your Honor, he's credit for time served. He's already been in 20 days, so. So, Mr. Wyatt, what the city is saying is that even though they're agreeing to dismiss the other charge, that they could recharge it again before the jurisdiction ends.
I love how she's using her best, hey, this is an asshole move voice.
What does that mean?
That means they can, Mr. Carver, could you?
What we're going to do, so Attorney Lamari, I understand this, you want to advise Mr. Ingram here on that. If you want an opportunity to have a breakout room with him, we can do that. But again, I don't want to have some, negotiations.
I understand, Your Honor, but I don't think a breakout room with him is going to help. I think I need to talk to Mr. Carver because this is the first time this has ever happened in ever. So I don't know what's happening.
Okay. Well, we are here on pretrial, and you can put Mr. Ingram back on the in custody calendar, within 24 hours notice. You don't have to wait for the next court date.
Your Honor, we don't want to do that. We're ready to resolve the case today. This is just,
Okay.
So, Mr. if I could just for the record, so the defendant and I both understand what it would mean for the case to be dismissed without prejudice under these circumstances, so that he understands and we can go forward the nature about which it could be recharged, just so he's clear on that. And then I think we'll be able to proceed.
All right. So we'll do that. So, Mr. Ingram, before we start going through the sort of the colloquies where we can talk about what it means to plead guilty to that charge of theft, it sounds like part of what the prosecutor will be doing is moving to dismiss the making a false statement to a public servant charge. Now, what it means when that's dismissed without prejudice, what that means is there's typically a 2-year statute of limitations on misdemeanor charges. And so they can refile that charge within that period of time. So they're saying they will dismiss it now, but could refile within that period of time that they're allowed to file the charge. And so that's what the agreement, or rather that's what the prosecutor is seeking to do.
Okay.
All right. It's your decision on whether or not to plead guilty. Based on that agreed recommendation, you obviously have advice from your attorney. And if you'd like more time to speak with her about that, you may, but that's what that means.
Yeah, okay, yeah, no, but I'm ready to resolve it.
All right.
Yes, Your Honor, we'd like to go forward.
Okay. All right. So, Mr. Ingram, so I do have in front of me a statement titled, a document titled Statement of Defense. You're agreeing to plead guilty to the charge of theft in the 3rd degree. That's a Sorry. Hang on. Well, the plea form provides the maximum penalties of a.
It's an attempted theft, Your Honor. It's a misdemeanor, max 90 days.
Plea is to attempt theft.
Correct, which is a misdemeanor.
Okay, I want to make sure we're all clear then, because the guilty plea does not say attempted theft.
Mine does, the one I sent to the court. It says attempted theft 3. Are we looking at Wyatt Ingram, Your Honor?
Yes.
Okay, the PDF I sent to the court, I printed it out. I'm looking at it. It says attempted theft and has a max 90 days.
So, first, we don't have a mutual agreement orally, and now even the paper is messed up. What's going on, you guys? Sounds like Carver and Lamari are having a difficult go at this case.
All right, Mr. Carver, is that the city's agreement as well? This is at a plea to an attempted theft?
That's correct.
Okay.
And that's
All right.
how it's charged, Your Honor. It's not an amendment. It's charged as attempted theft. The amended complaint was filed on February 3rd.
All right, I see a docket note for amended complaint received. Okay, well, all right. So it sounds like there's an agreement to an amended complaint of attempted theft, which is a simple misdemeanor. So thank you for clarifying. And to the extent there's been some document turnover, between the courts, that may have gotten lost. But so I just want to make sure I'm on the same page as the attorneys here. So thank you for clarifying. So, Mr. Ingram, you're sitting through a lot of kind of nuanced, complicated discussions here about the charges against you. I apologize for that. So let me be clear. So you're agreeing to plead guilty to the charge of attempted theft in the 3rd degree. As Attorney Lamari there noted, that is a simple misdemeanor,
Yes.
meaning it's punishable by maximum penalties of 90 days jail and a $1,000 fine. Do you feel you've had enough time to go over this document with your attorney?
Yes.
All right. Paragraph 5 of the plea form outlines certain important constitutional rights that you're agreeing to waive by pleading guilty. Do you have any questions about those rights?
No, Your Honor, I do not.
And do you understand that an agreed recommendation to a judge is just that? It's a recommendation, and the judge doesn't have to follow it, but could sentence you up to the maximum penalty, which I went over there a moment ago. And if so, that would not be a basis for withdrawing your plea. Do you understand that?
Yes, sir.
That said, it looks like the agreed recommendation here to the court is plead guilty to this charge. Conditions of no new law violations, probation for 12 months. Conditions on probation are to stay away from big stump bicycles. And then the dismissal, again, without prejudice on the other charge, the making false statement to a public servant. Understanding we had that discussion about prejudice versus without prejudice. Is that your understanding of the agreement?
Yes.
All right. Okay. I see here the box is checked that you've been advised that if you were not a U.S. citizen, a guilty plea could have adverse immigration consequences. Do you have any questions about that?
No.
Has anyone made any threats or promises to get you to change your plea today?
No.
Paragraph 11 of the plea form outlines a statement of fact that is used to support the change of plea. I'll read that to you and ask you if it's accurate. And that reads that on January 24th, 2026 in the city of Olympia, I attempted to take the property from Big Stump Bicycles without paying with the intent to deprive Big Stump of their property. Sir, is that an accurate statement in your own words?
Yes, Your Honor.
All right. And to that charge of attempted theft in the 3rd degree, how do you plead?
Guilty.
I find Mr. Ingram's plea of guilty to be knowingly, intelligently, and voluntarily made with an understanding of the charges and consequences of the plea. And there's a factual basis for the plea. All right. So, Mr. Ingram, what I'm going to do next is sign the plea form, and then I'm going to turn it over to the attorneys to talk about that agreed recommendation. Then I'll turn it back to you. You'll have the opportunity to say something if you wish before sentencing. You don't have to say anything if you don't want to. And I will start with the prosecutor, Mr. Carver.
Nothing further from the city, Your Honor. We would just ask the court to follow the recommendations. A big part of this is just him staying away from stump bicycles.
That's big stump bicycles, Mr. Carver. Big stump. That sounds really dirty. Really dirty.
Thank you.
Yes, Your Honor. I just asked the court to follow the agreed recommendation. I believe he has 19 days, credit for 19 days, so which would leave 71 suspended.
All right. Thank you. All right, over to you, Mr. Ingram. Again, you don't have to say anything if you don't want to, but now's your opportunity.
No, sir.
All right, so this has been negotiated between the parties and sounds reasonable to me, so I'll impose the 90 days, suspend 71, give you credit for time served. All right, so that should result in your release here. Not going to impose any fines or fees, given the conditions of probation are to stay away from big stump bicycles as well as law-abiding behavior. That will be for a period of 12 months. And as part of this plea again, the other charge will be dismissed without prejudice. Okay. Any questions, sir?
No, Your Honor.
All right. You'll get a copy of the judgment and sentence for both this case, as well as a copy of the judgment sentence dismissing the other case there at Nisqually. Nothing you need to do with either of those. You can just keep them for your own records.
Okay, thank you so much, Your Honor.
Thank you. Free to be taken back.
Oh my gosh. Big stump bicycles. You'll love the ride. Oh my. I'm sorry, Manny. It wasn't me, my love. Yeah, I'm not a movie person, so okay, so for people who aren't in the chat, I made a comment that I don't think I've ever seen anyone wear a collared shirt and tie, wool sweater, and a suit jacket like Mr. 1974 over there. It's just wardrobe I haven't seen, right? Jason goes on to name a whole bunch of things I haven't seen. I do recall I did watch was it American Pie with one time at band camp, but I don't remember a whole lot of it. I remember Stifler's mom was a big thing apparently because she was boning one of the kids, I guess. Teenage, adult, or on the verge of adult boys. YouTube, I'm talking about like an 18-year-old teenage. Got to make sure I clarify. Yeah, I don't watch TV. I told you all that earlier. Like my TV circle is limited to YouTube videos. Oh my goodness, they've made a mess. They're not happy because their treats are not treats right now. It's regular cat kibble. But they're still eating it. They still think it's a treat to eat next to Mama. Oh, Charlie. A big stump, clearly. Okay. I wasn't wrong. I wasn't wrong. I know I saw it, but I don't remember it. It didn't really make a big impression on me. Everybody thought it was like the greatest thing ever, and I was like, oh, yeah, it's funny. Okay. Next. I don't get obsessive over movies, really. Not really, I guess. Some I get excited for, but I'm not that interesting of a person, I guess. I do remember VHS tapes. Yes, we had every Star Trek episode ever on VHS tapes that my parents recorded. Yep. And cataloged. Kept a notebook. Which number correlated to which videos, and then all neatly in the catalog. It was about the only thing my parents ever cataloged in their entire existence. Was every single Star Trek episode that they had on VHS. Thank you, Patrick B. I had fun snatching them as they were trying to walk across the desk tonight. Every time they'd walk across, I'd snatch them up. I did it with Tiny Kitten, and I did it with Billy. I don't dare do it with Earl. Earl does not like to be held. Not at all. And that's a good way for me to end up with lots of more scratches. Kitty scratches, they don't feel so good. They kind of get burny hot. All right. Hey, welcome. Yes, that's exactly what I meant. I gotta make sure YouTube knows. Long time ago. Yes, it is Eileen and Carlin, honey. I swear I thought you were here earlier. Am I crazy? I might be crazy. Absolutely. Oh my gosh. You should see all the Star Trek stuff that I have. Oh, I'll be right back. Hold on. Give me 1 second. Okay, so normally my blanket that was on the back of the couch was a Star Trek tapestry. Okay, I literally just right outside my door. There's a bookshelf, and these are on it. So I think I took the battery out of this. Yeah, I did. I need to buy some batteries. I needed batteries for something else. But anyways, I have this glittery snow globe, and when it has batteries in it, it lights up and it looks like a nebula. It's so beautiful. Yes, so I have this one, and this is the 1701D. And then, so this I made myself. Okay, so Star Trek had these these currency bills, and you guys all know I collect money. I collect coins. I collect bills. I have I I have the 1993 series with the $3 novelty bills with Bill on them. You know, so when I saw this, I went nuts and I had to buy them. There's a glare. I'm trying to get away. Okay. So 50 Federation credits. And then the Leonard Nimoy $1 million bill. No, it gets better. It gets better. So I built this on a rotating base so that the other side, these are crushed glass and gemstones to make it look like they're entering a nebula. And it has the reverse side of the bills. I love it so much. I love it so much. So I made that. Nope, I'm not a nerd at all. Not even a little bit. No, I don't cosplay. I don't dress up and you know, go to events and things like that, you know. I'm not that kind of nerd. I love Star Trek. Hello, sweetie. I hope you and the kitties are doing well tonight. I'll be honest. The first is actually my least favorite. I'm sorry. Don't hate me. I'm not a Shatner fan. He's too self-centered and arrogant. I've never really went there. He's not my favorite, but I love Leonard Nimoy. Oh, I love that man. Till the day he passed, I loved that man. My favorite, my favorites, I love all of them so much that it's like, it's hard to pick. I think, which one was it with the female captain? It was one of the later ones. Not the most latest one. That wasn't Voyager. No. I did love Voyager, but the one with oh my god, I'm so tired and I can't even think right now. Okay. How about this? Because I'm not great with episodes, but I can tell you my favorite characters. Quark. Absolutely love Quark. I would rub those ears all day long. 7 of 9. Of course. She's one of my favorites. I adore her. Let's see. I really liked Captain Jane. Or it was Janeway, right? Captain Janeway. Was that it? God, I'm so tired. Hold on. I haven't watched them for so long. It's been such a minute. Yeah, Catherine Janeway. And she was Voyager. Yeah. Yes. I think I liked that one the most because I felt like when it ended, it had like it felt like you completed it. You know, the mission was completed. And I really love all the twists and turns that it went through. And then after that, they came out with the next series that was actually, even though it was after Voyager, it was dated like right after the original series. If I remember correctly. Chakotay. Oh my god, I loved Chakotay. Let's see here. I'm gonna have to go back and review because as you all know, I'm not great on the fly with like names and dates. I gotta actually like think of things. But I'm cruising through here really super quick to see if any more names pop out. But this is all just on Captain Janeway, so I doubt I'm gonna see much for names other than her. Tom Paris. Yep, I do see 7 of 9 listed on here. Yeah, so I think Voyager probably one of my favorites. But it's so hard to pick. And yes. Captain Picard was he's my absolute 100% favorite captain. Like hands down, Captain Picard he's the best. It doesn't get better than that. But as far as storyline goes, I was most entranced by Voyager. Okay. And by the way, I couldn't see anybody's comments because I was off screen there. Oh, yeah. Oh, see, you are my brother. I swear. We share a brain cell. Some days I have it, some days you have it. I know. I know. It's not. Yes. See, I'm not a people person though. I just like peopling takes so much out of me. My daughter went to Comic-Con. I don't think I could. I don't think I could do. I had a hard enough time doing run fairs. Like just so many people around me all the time. I struggle with that. I can do it, but by the time I'm done, I'm so mentally and emotionally exhausted that I need like 3 days to physically recover. It's crazy. See, and I couldn't see any of you guys' comments. Oh, yes. Oh my God, I love him. Oh, I love him. I did have a batleth for a very long time. I gave it to my father, and then after my father passed away, I gave it to my ex-husband because he actually gets enjoyment out of taking swords into the woods and learning different moves and things like that. And I knew having the batleth would be something he would greatly enjoy. I could have it and it would sit on my wall and I would like to look at it. He would physically utilize it, not on people, but I think that would give him so much more joy than what it would give me. I know I'm a sucker. Leonard Nimoy, he was a real singer. He wanted to be a professional singer. That was one of his dreams and goals. And he has a couple albums out there if you didn't know. They're not too bad. He did If I Were a Carpenter and You Were a Lady. Yeah, I love that song. Nimoy singing Bilbo Baggins. Yes, yes. No, I know that. I can't. You don't think that that song would instantly get copyright struck? It would. Like, it's kind of well known. But everybody else can Google it. Everyone else can Google it. All right, guys. Peer pressure. No, guys, I can't do it. I can't. It would demonetize the whole video and give me a strike. YouTube would be mean about it. They don't. YouTube is very strict on music. Like, the only thing I can play are the intros and outros that I have paid to have made into music, and then the Mighty Metheny that I wrote and I had made into music. I can play those. I don't think that works with music, because I would have to put, there's a lot of stuff you have to do with music in order to make it accepted that I don't know. I'm serious. I don't. Like, I know I've seen other people do things like that, but I'll put it this way. Okay, so one of the body cam videos that I did one night, it was recent too. Which stream was it? One of my body cam streams. At the outro, the music that the body cam video people played, it caught me a ding. It wasn't a strike, but I had to mute all of the audio from that section. So, and I think it overlapped with part of the content creators commentary. And so, like, the person's talking and all of a sudden it just stops talking and it's just mute for the rest of for a little bit of the video, and then thanks for watching and subscribe, like, blah, blah, blah. Yeah, I don't know where to put the credits or how to incorporate the credit. I just don't know all that stuff, guys. I'm not smart. I'm sorry. I could probably learn, but not right now because I'm super tired and I'm going to go to bed. Yeah, thank you so much. You guys have been amazing as always. As always. And I'm so glad that you guys were here. Be safe, be well, sleep sweet, and much love.